actually asked someone to call you because everybody has spoken, you have not. So what is your position? How much time are you asking for?
My lady, I'm not aware how much time my colleagues have requested for.
Okay.
My only
The applicants have asked for 40 minutes, Mr. Kwegi for 20. The others, apart from you, have said they are not participating. Others have surrendered their time and associated themselves with the submissions of the petitioners.
We are okay with about 6 minutes, but our only contribution would be this, my lady. There's an application of 15 which says, please exempt me from exhausting internal remedies. Then Mr. Harvey's application says, this matter is premature because it was filed before exemption. It's an answer. So both should be heard together. Otherwise, 6 minutes would be good enough for us.
So you are still taking your position that both applications should be heard together.
One is an answer.
They want to argue their application, the one of, if I have it right,
remove the microphone,
of 18. And I think that's what was fixed for today.
Yes.
Happy?
My lady.
18th of July 2021.
My lady, your brother Justice Chemitei was confronted with the two applications when the matter was before him on 27th of July. And upon taking submissions, he gave a ruling that the application by us be heard first because it goes to the question of jurisdiction. I do not think it is proper to revisit that issue in the manner intended by Mr. Dudley Ochieng.
Thank you. So that it's very clear from the record, and that's why I'm saying the only application that's coming for hearing today, the application dated 18th of July 2021. And with that, I think maybe a couple of minutes, can you take it to practice?
Yes, my lady, I can be brief. I can be brief. Yes.
Then Mr. Kweki, and then Mr. Mr. Harvey.
My lady, what is before you is the motion by the Law Society of Kenya and its council members dated 18th of July 2021. My lady, in that motion, an order is sought to strike out the petition dated 15th July 2021 on account of 4 grounds. The first being that the petition is sub judice. The second being that the petition is res judicata. The third being that the petition is an abuse of the process of court. And the last being that there is no jurisdiction to entertain the petition. My lady, we have filed submissions which are dated 30th July 2021. My lady, as a background, the Law Society of Kenya is a statutory society established under the Law Society of Kenya Act. My lady, the overall decision-making organ of the society is the General Meeting under Section 16 of the Act. My lady, under section 36 of the Act, decisions of the society can only be altered within 9 months through subsequent resolutions of the society. My lady, there is an inbuilt mechanism for determination of disputes relating to the management of the society. And this inbuilt mechanism is anchored upon section 41, paragraph Q, as well as regulations 95 and 96 of the LSK regulations 2020. My lady, that statutory and regulatory regime provides mandatorily that all disputes be subjected to negotiation, conciliation, mediation, and arbitration. My lady, permit me to entrench those provisions with the requirement under Article 159, Sub-Article 2, Paragraph C of the Constitution, which empowers the court to embrace alternative dispute resolution mechanisms. My lady, let me go back to the petition and indicate why it ought to be struck out on account of the 4 grounds I've just enumerated. My lady, in this petition, a raft of orders are sought to invalidate all resolutions made at the special general meeting convened by members and held on 26th June 2021. My lady, a further order is sought to declare myself as unfit to hold the office of President of the Law Society of Kenya or any public office within Kenya. My lady, the following is the reasons as to why the petition is sub judice. My lady, there is pending before the High Court in Nairobi petition number E260 of 2001, of 2021, in which the first petitioner therein, the second petitioner therein is the first petitioner in the petition before you. My lady, in that petition,
Maybe just for purposes of
okay.
any confusion, you can name the petitioners.
Oh, sorry. My lady, in that petition, the second petitioner, Collins Odhiambo Odundo,
Yes.
whilst in this petition, the first petitioner is again Collins Odhiambo Odundo.
Yes.
My lady, the date of filing of the two petitions, the parties, and the order sought fall within the category of what is sub judice. My lady, petition number 260 of 2021 was filed on 5th July 2021, 10 days after the meeting of 26th June 2021. My lady, this petition is filed on 15th of July 15th of July 2021, 10 days after the filing of the petition in Nairobi. My lady, in both petitions, the management of the Law Society is impugned. My lady, in both petitions, an order is sought to declare myself as unsuitable to serve. My lady, the only difference is this. In petition number 260 of 2021, an order was not sought to invalidate the resolutions made on 26th of June 2021. My lady, the question therefore begs whether by virtue of that omission and the inclusion of other orders in the subsequent petition, the petitioner can escape the rule against sub judice as formulated under Section 6 of the Civil Procedure Act. My lady, the explanation to Section 6, explanation number 4, captures the petitioners in this petition. Explanation number 4 to Section 6 reads as follows: any matter which might and ought to have been made a ground of defense or attack in the former suit shall be deemed to have been a matter directly and substantially in issue in the suit. My lady, it is my submission that the petitioners in this case were aware of all the facts found in the subsequent suit and ought to have made it a point of attack in the suit filed in Nairobi. My lady, the doctrine of sub judice is intended to avoid an abuse of the process of the court and a situation where parties seek to have courts of competent jurisdiction make contradictory decisions. My lady, as 10 all the way to paragraph 23 of my submissions, I've enumerated several cases which support the submission that this petition is bad on account of sub judice. My lady, permit me only to highlight one which appears at paragraph 22. My lady, I don't know whether we are together because the screen looks like it has hung.
I am with you.
Thank you. Thank you, my lady.
Yeah.
My lady, at paragraph 23 is the case of Republic. 22, my lady, is the case of Republic versus Paul Kiara Kariuki. And in this case, your brother, Justice Mativo, points out 4 significant facets of sub judice. 1, that the mere addition of a party or parties to the subsequent suit does not remove the party from application of the doctrine. Number 2, that a party to a previous suit should not gamble and take chance with 2 courts expecting a favorable decision in the subsequent court. Number 3, my lady.
You said the second one? The second one first before you go?
My lady, the second one, a party should not gamble with 2 courts with expectation of a favorable judgment in the subsequent court.
Yes.
Number 3, my lady, that courts ought to discourage the multiplicity of actions even when the party has a right of action. And number 4, which applies hook, line, and sinker to this case, that the concealment of the previous suit is of itself a ground indicative of the attempt towards a gamble by the party filing the subsequent suit. My lady, let me now address the issue of res judicata. And for this, my lady, it is the premise of the applicants that the issues now sought to be litigated before you were determined with finality by your sister, as she then was, Justice Pauline Nyamwea, on 7th May 2021. My lady, you will find the judgment of your sister at page 250 to page 285 of the exhibits to the replying affidavit of the Vice President, sworn on 18th July 2021. My lady, the case in issue is JR number E1146 of 2020. My lady, in that case, the ex parte applicant challenged the manner of requisitioning and holding of an SGM requisitioned for 5th of December 2020. My lady, you will find the determination by your sister, which is imperative, at page 274 henceforth. And permit me to read what your sister said at page 274. In addition, the Law Society of Kenya in section 16 provides that the general meeting are the supreme authority of the society, which shall approve all resolutions and important decisions of the society. And then at page 275, my lady, your sister says as follows: a dispute as regards the convening of a general meeting is therefore one that touches on the management of the Law Society as well as the rights of its members in this regard, and is amenable to arbitration. Now, concerning the propriety of the alternative dispute resolution mechanism, this is what your sister said at paragraph 53. Paragraph 53, my lady.
That page?
Page 275. My lady, your sister said this: it is my view that it is in the public interest that the members of the third respondent be given the opportunity to resolve their apparent differences amongst themselves using old laid down procedures before seeking the intervention of the court. And my lady, in her disposition, your sister discharged the order she had made on 3rd December, stopping the conduct of that SGM. It is as a result of that order that the SGM was eventually held on the 26th of June 2021. My lady, the question therefore begs, what should be the recourse of anybody dissatisfied with the resolutions of 26 June 2021? Should they go back to court in a different suit, or must they abide by the decision by Nyamweje that such a dispute be resolved in a subsequent general meeting under section 16 and 33, or be dealt with through alternative dispute resolution? My lady, in answer to that question, I submit that it is improper for the petitioners to disregard that decision and file another suit. And my lady, perhaps just a cursory look at the replying affidavit of Collins Odhiambo Odundo, sworn on 24th of July 2021, suffices to place this petition within the ambit of res judicata. My lady, this is what Odundo says at paragraph 8 of his affidavit. Paragraph 8. He says that our cause of action is premised on the facts that took place from the time the SGM was advertised to the time the SGM was held and resolution passed. My lady, there can never be a better case of res judicata than this one. My lady, you will find that paragraphs 24 all the way to paragraph 33 where we have enumerated several cases that support our argument on res judicata. My lady, for precision, allow me just to rely upon one case which is celebrated in the regime of res judicata. And this, you will find it at paragraph 31 of my submissions. It is the case of Mburu Kinywa versus Gashini Tuti. Mburu Kinywa versus Gashini Tuti. My lady, the gravamen of Mburu Kinywa is this: that where there's been a final determination even if it is on jurisdiction and not on merit, a subsequent claim over the same subject matter is res judicata. My lady, on this point, a response will be made by the petitioners and some of the interested parties that there has been a decision made on 3rd February 2021 and another one made on the 27th February 2021 by Justices Weldon Korir and Jairus Nga. My lady, it will be submitted to you that by virtue of those two decisions, a member of the Law Society can still come to court, notwithstanding the alternative dispute resolution mechanism. My lady, I will deal with that issue substantively in the second subheading of jurisdiction, but for the purposes of this petition, the judgment of your sister Pauline Nyamweya was issue specific to this special general meeting and the question of jurisdiction. My lady, over and above that, Nyamweya's decision judgment, whereas the decisions of your two brothers are interlocutory. My lady, last and fundamental is that the decision of Justice Pauline Nyamweya is later in time on this matter. My lady, I submit that the case for res judicata has been made out. My lady, on the last point, on jurisdiction, it is the submission of the Law Society of Kenya premised upon the judgment of Justice Pauline Nyamweya, that internal disputes of the Law Society of Kenya are not to be subjected to judicial intervention before the High Court before exhaustion of alternative dispute resolution mechanisms. My lady, at paragraphs 34 all the way to paragraph 43, I have set out several decisions of the High Court and of the Court of Appeal underscoring the necessity to exhaust alternative dispute resolution mechanism. My lady, I dare say it is a constitutional edit. The Constitution compels exhaustion. My lady, two arguments are espoused by the petitioners and surprisingly supported by some of the interested parties and the third respondent. My lady, these are the arguments. First, that the Vice President and I have refused and or failed to pursue arbitration as directed by Justice Pauline Nyamweya. My lady, secondly, it is argued that the council is dysfunctional. There are parallel communications coming from the two factions. And for that reason, alternative dispute is incapable of being attained. My lady, permit me to dispose of the first ground. My lady, the ex parte applicant in the judgment delivered by your sister was Gad Aguko. His grievance was targeted at 3 respondents. 1, myself, Nelson, and I, Harvey. 2, the third respondent herein, Mercy Kalondu Wambua. And 3, the fourth respondent herein, Law Society of Kenya. My lady, your sister directed that the dispute by Gad Aguko be processed through the alternative dispute resolution mechanism. My lady, arbitration is adversarial in nature. It is moved by the claimant. It cannot therefore be said that it was our responsibility to propel that arbitration. My lady, similarly, it cannot be asserted there's somebody who's in traffic. Yeah, sorry. It cannot be asserted that the abandonment of that dispute precluded members from holding an SGM on 26 June 2021. My lady, on the second ground, an express reading of Regulation 95 and 96 will disclose that the president of the Law Society, the vice president, and the Law Society itself do not play a role in initiating, appointing an arbitrator, or progressing the arbitration.
Maybe we've now just done about 40 minutes, which is the time allocated to my learned friend. That's so chill. Thank you.
12:15. We started at 12:15.
Yes, we did.
My lady, I'm about to finish. I'm going slowly because of the limitations of the virtual platform, but I'm about to finish. I won't take much longer. My sincere apologies.
Just a minute, let me get some water.
Okay.
Just put some. Okay. So, yes, you can continue.
Yes, my lady, the arbitrator is first appointed by the parties. So that in this case, it is Collins Odundo, John Ochola, to initiate the appointment of the arbitrator. The 11 of us, as respondents, can either agree or reject their choice of arbitrator. In the event of disagreement, the arbitrator is appointed by the chairperson of the Chartered Institute of Arbitrators. My lady, even without struggling to interpret what Justice Korir and Nga held, which you are not bound with, and which I have also indicated to you were interlocutory decisions, an express reading of Regulation 85 and 86 confirms that the so-called dysfunction,
You said regulation?
85 and 86, the so-called dysfunction cannot be a ground to avoid alternative dispute resolution. My lady, there are two decisions that have been relied upon by the petitioners as well as no, let me use my time in reply to deal with the decisions. My lady, those five, yes, I'll finish in 2 minutes. My lady, those three grounds culminate in the composite ultimate ground of abuse of the process of the court. My lady, I beseech you to contain this abuse by striking out the petition. At the filing of the petition, we had sought an alternative order of transferring it to Nairobi But it is my humble view that on the evidence and the law presented to you, that avenue is unnecessary. Please, if you manage to get conviction in our arguments, strike out the petition, my lady. My lady, in one line, in conclusion, it must be understood that the resolutions of 26 June are anchored upon the final decision-making powers of members, and under section 16 and 33, that decision of members ought to be altered only by members themselves.
Thank you.
I pray you allow the application. Thank you so much, my lady.
Thank you, Mr. Harvey. Next, rejoinder.
My lady, permit me in my rejoinder to speak to you first as an advocate.
Yes, I was going to say that I have hearings from 2 p.m.
Okay.
So we need to...
I'll make it short. I'll make it short. Maybe even less than 5 if I'm able to. My lady, with a lot of humility, permit me to speak to you first as an advocate and second as a judge of the High Court. I say this because 15 years ago, as a practitioner of 2 years practice experience, my mentor, Justice Otieno Kwach, told me, a judge is first an advocate.
My lady, the point Savi is making...
My lady, with tremendous respect, Mr. Dudley Ochel has been very condescending, insulting in all matters I appear. I humbly plead with you to ask him to allow me to finish my submissions. It's not necessary.
Please allow Mr. Harvey to speak. Yes.
Most of you're just worried about the content of the rejoinder.
Yes.
If it is true.
You'll hear where we get to see where it's going, because it's just made an introduction, so I'm waiting for the content.
Most of
My lady, I want us to consider this question. Are there contradictory decisions of the High Court on the jurisdiction relating to LSK matters? And my lady, if you answer this question in the affirmative, then there is a proper understanding as to why the filing of this petition offends the 3 paramount grounds I've said. My lady, whatever the prolificity of the pleas in this petition, notwithstanding the addition of parties and prayers, there is only one primordial question. And the question is this: can the High Court ignore Section 16 of the Law Society Act? Should the High Court put aside Section 33 of the Law Society Act, Section 41, paragraph Q, Regulation 95 and 96, and Article 159, and determine an internal dispute of the Law Society of Kenya. That's the issue here. My lady, and as you ponder over that issue, bear in mind that in petition number 260 of 2021, Collins Odhiambo Odundo versus Nelson Harvey, your brother Justice Murima has reserved a ruling on that issue for delivery on 19th of August 2021, 2 days from now. My lady, notwithstanding that background, you're being told to assume jurisdiction over this matter, in the words of my learned colleague and friend, Mr. Koigi, because Article 22 of the Constitution guarantees the petitioner a right to fair trial. My lady, the right to fair trial is not the same thing as an impartial court or tribunal. That dichotomy ought to be clear. And the reason is this. Article 159 of the Constitution has recognized alternative dispute resolution as an avenue where one can go to have a fair trial. My lady, it follows therefore that the complaint by Mr. Koigi that the right to file a petition cannot be limited is without legal foundation. My lady, permit me to distinguish the two cases relied upon by Mr. Koigi. Mr. Koigi cited the case of Secretary County Public Service Board versus Mr. Geddy as authority for the proposition that the petitioners are entitled to come to this court because alternative dispute resolution is not a forum where the dispute can effectively be dealt with. My lady, a decision is relied upon on account of its ratio decidendi. It is the gravamen of the case that forms precedent. My lady, in this decision, the Court of Appeal upheld the challenge based on alternative dispute resolution. So the decision cannot avail reprieve to the petitioners. In this decision, the Court of Appeal reiterates exhaustion. The second decision relied upon by my learned friend and colleague, Mr. Koigi, And I ask my learned friends to understand that in court, however much you dislike somebody, you refer to them as my learned friend, Mr. or Mrs. Is the case of Diara Enterprises versus Nairobi City County Government. My lady, it was argued on the strength of this decision by Mr. Koigi that the court can be approached directly. Again, my lord, my lady, a reading of this judgment confirms that the Court of Appeal upheld the objection on exhaustion. And the Court of Appeal went further. It reiterated the case of owners of motor vessel Lillian S. And the principle set out therein that if the court does not have jurisdiction, it must down its tools. You're being asked to put your tools on the workshop table, on the backdrop of this fundamental challenge to jurisdiction. My lady, lastly, it was submitted by my learned colleagues, Mr. Koigi and Mr. Odundo, that in this petition, there are more parties who are not lawyers, and for that reason, they cannot be subjected to alternative dispute resolution. My lady, two issues dispose of that assertion. What is the prayer sought in the petition? Is there relief against the banks and Safaricom? None. Number two, my lady, is there a plea of violation against the banks or Safaricom? None. My lady, this is what we call abuse of the process of the court. To use the words of Justice Richard Kuloba as then was, it is galloping, trying here, trying there, with the hope that the game of chance will nail the respondent. My lady, the premise, lastly, by those two friends of mine is this: that they do not know who the Council of the Law Society of Kenya is. They do not know who speaks for the Law Society. And for that reason, it will not be known who will act in the arbitration. My lady, the filing of this petition itself answers their question in two aspects. This SGM was requisitioned by 700 members. Their names are here in the petition listed. The petitioners have not sued those 700 members. They have sued me. Why? Because I speak as the authorized official spokesperson of the Law Society. My lady, this argument does not germinate from my head. It's an argument that has found legal authority in a decision given by your brother, Justice Odunga, in JR number 3 of 2021. My lady, that case is exhibited with the affidavit of Caroline Kamende, commencing at page 261.
Then you have 2 minutes.
My lady, I want to finish in those 2 minutes. Yeah, my lady, it's page 261. Page 261. You will find the holding itself at page 262. Sorry, no. You will find the holding at page 646, my lady. 646 to 647. My lady, this is the case concerning the appointment of the representative of the Law Society to the IBC selection panel. The third respondent, Mercy Kalondu Wambua, had attempted to countermand an appointment I made. In that case, Justice Odunga said there can be no council without the president or the vice president. He further said the decision of the president communicated on behalf of the Law Society cannot be countermanded by anybody, not a council member, not the secretary. If dissatisfied, you go to court to challenge it. My lady, it is my humble submission that I have settled the issues by the petitioners. One issue coming from the submissions of Mr. Dudley Ochiel. And my lady, this must disturb you, and it must disturb you profoundly. We have a respondent who is supporting a petition filed against her. It should disturb you, because that is the same thing that happened in many cases pending before this court. And my lady, I know you've read the book by Paul Mwangi called The Black Bar. What is happening today in the Law Society is the same thing that happened in 1991. Where the leadership of the society is sought to be countermanded from performing, using its own members and officials. It's not novel. It has happened. My lady, I humbly beseech you to refuse to seize jurisdiction, because if you do, we will end up with a situation where a decision contradicting that made by your sister Justice Nyamwea, where a decision contradicting that to be made by Justice Murima 2 days from now will be made. The petitioners must be asked to stop abusing the process of the court. It's only through that avenue that genuine disputes can be handled and the society able to function. And believe, now that I'm concluding, I plead with you, if you could kindly spare a few days during the vacation to write this decision, so that we know whether we'll go on with the petition or we can go elsewhere. And the reason is this: like the banks have refused to honor our instructions on payment of monies because they are claiming there is a matter in court. I mean, my lady, I must be frank with you. In my office, I'm able to pay my staff. But at the Law Society, there's no power. Water was cut as I watched. We can't pay for internet because the banks are saying the matter is pending in court. We will be happy to know whether, if the court is going to hear the petition, so that we know what breaks to take. But if we are going another avenue, so that we're able to serve members. It's a plea that I must make, because I've taken the duty to serve members of the Law Society. If I don't do that, I'll be failing. Thank you, my lady.
My lady, just a quick point.
Yes.
Two, in fact. One,
Please speaking, please.
my name is Ochiel Dudley.
Yes.
Two very quick points. One, Mr. Harvey knows that there is 1 month.
Will I deal with that now, coming at the tail end of the arguments?
And my lady, more fundamentally, what should concern you, a respondent is asking for relief. There is a problem. Yeah, there is a problem. And my lady, on 3 occasions.
At the tail end of the arguments, because I wish that had come at the beginning. Then in my head I would have an idea of what it is that you want, but I can't start thinking about it now. I can try and do what council has asked, try and find time during this
Could my lady order parties to sustain the status quo and to hold any further activity in regard to those resolutions? It would be fair to both sides.
I don't know how to start doing that.
No, my lady, I still plead with you. We need to know who the petitioner is and who the respondent is. This is mischievous.
I don't want to go into that, Mr. Harvey, because I have had the application before me. I have had it.
Yes.
Isn't
Thank
what
you.
I was supposed to hear today? I have had.
Okay.
Now, my problem is when this comes at the tail end of the application, I am concerned, because I should have been addressed so that you would have been able, or whoever else would have been able to raise those issues. Like Mr. Ochen, if you are just on interim orders.
You just say, stop playing with the microphone.
My lady, may I also point out that my colleagues have made this attempt on 4 occasions now, before 3 different judges, and the courts have declined. With respect, they want to steal a match before you, my lady.
Because if this had been done, then I think I'll be remembering that what the other parties had said. You know,
my lady, that is why we were urging you hear both applications today.
Let me deal with what I have before me. I've said that I look for time. Right? But you can, whatever else that needs to be done can be done. I think that is the concern I have as well. That is not, actually, I don't recall it being argued. In my handwritten note, that there's that application for interim orders for interim relief. I don't recall. Has just died.
Joseph,
Okay.
why?
So now, this week, I have a course list, the whole of this week. So I can't promise I'll have time to look at the 5. But in the next 2 weeks, I can look at the 5.
Joseph, give me the microphone.
Hello? I'm not hearing you people.
My lady, we'll be happy if the 2 weeks is what you require. We can give us a judgment, a ruling date within 2 weeks.
And see how my days are. So if up to now I'm still sitting and I have another hearing, I would not even have a chance to open the file.
Okay.
So in the next 2 weeks, I can look at the file, and now if we take 14 days from today, we can see which date we can try and see if we can take. That's myself. Yes.
On the 6th of September.
That's 2 weeks from now. Now, because
My lady, you said 6th of September.
6th of September.
Yes, 6th of September. That's 3 weeks from now, because this week I will not have time at all.
Thank you, my lady. We're most
We are most
grateful.
obliged.
I'm also grateful to my colleagues.
And should I be able to do it earlier, I will let you know. Your email addresses are here. Should I be able to do it within the next week, I will let you know. Because I can hear Mr. Koiti and the agency in the matter, see that I'm not able to do what was expected.
Thank you, my lady.
We appreciate and
Thank you very
no
much.
problem.
And I pray that we can try and now this is not me as now the judge, it's as the advocate. We can try and
Jose, give me the
I don't know
microphone.
what to find. Just do things the way we are supposed to do things as advocates. In the meantime, because at least the matter is before me, if there's anything before me that needs people to just do what they're supposed to do, be nice to one another. That's the best I can do. I can't say more. I can only say let's be nice to each other.
Thank you, my lady. We will try.
Thank you and have a good afternoon.
Thank you very much. Edna, we had a question matter.